excuse me, Rushwood CC&Rs.
Here we go. Whether you've skimmed them, ignored them, or had no idea they existed, don't worry, I didn't either. These are Rushwood CC&Rs, the rules we all agreed to, I swear. Let's start reading, and who knows, it might even get exciting.
Disclaimer. This audio was created solely for accessibility purposes and is not an official legal document. The content was sourced from Rushwood's officially recorded CC&Rs, which can be accessed via the link below. A special thanks to Shreyas Bharadwaj for his quiet and valuable contribution to this effort by implementing optical character recognition, OCR, to extract the text from the original CC&Rs. This project was independently produced and funded by Edgar to support greater community awareness and accessibility.
If this document contains any restriction based on age, race, color, religion, sex, gender identity, gender expression, sexual orientation, familial status, marital status, disability, veteran or military status, genetic information, national origin, source of income as defined in Subdivision P of Section 12955, or ancestry, that restriction violates state and federal fair housing laws and is void, and may be removed pursuant to Section 12956.2 of the Government Code by submitting a restrictive covenant modification form together with a copy of the attached document with the unlawful provision redacted to the County Recorder's Office. The restrictive covenant modification form can be obtained from the County Recorder's Office and may be available on its internet website. The form may also be available from the party that provided you with this document. Lawful restrictions under state and federal law on the age of occupants in senior housing or housing for older persons shall not be construed as restrictions based on familial status. This declaration is made as of the date set forth below by the undersigned declarant.
Recitals. 1. Declarant is the owner of certain real property located in the city of Rosemead, County of Los Angeles, hereinafter referred to as said county, State of California, described in Exhibit A attached hereto. 2. Declarant is improved or intends to improve said real property in the manner described in Exhibit C attached hereto. 3. All of said real property, including all structures and other improvements thereon, is hereby defined and shall hereinafter be referred to as the development. Declaration. Now, therefore, declarant hereby declares that the real property described in Recital 1 above is and shall be held, conveyed, hypothecated, encumbered, leased, rented, used, and occupied, subject to the following limitations, restrictions, easements, covenants, conditions, liens, and charges, all of which are declared and agreed to be in furtherance of a plan of condominium ownership as described in Section 1350 to 1459, inclusive of the California Civil Code, for the subdivision, improvement, protection, maintenance, and sale of condominiums within the aforesaid real property, and all of which are declared and agreed to before the purpose of enhancing, maintaining, and protecting the value and attractiveness of the aforesaid real property. All of said limitations, restrictions, easements, covenants, conditions, liens, and charges shall run with the land, shall be binding upon, and inure to the benefit of all parties having or acquiring any right, title, or interest in the aforesaid real property, and shall be binding upon, and inure to the benefit of the successors in interest of such parties. Declarant hereby further declares that it is the express purport and intent hereof that this declaration satisfy the requirements of Section 1355 of the California Civil Code.
Article 1.
Definitions. 1. The association shall mean and refer to Rosewood Owners Association, its successors and assigns. 2. The board shall mean the Board of Governors of the association. 3. The bylaws shall mean the bylaws of the association, as such bylaws may be amended from time to time. 4. The common area shall mean the entire development, excepting all units as shown on the condominium plan. 5. A condominium shall mean an estate in real property as defined in Section 783 of the California Civil Code, consisting of an undivided interest as a tenant in common in the common area of the development, together with a fee interest in a unit defined below, shown and described on the condominium plan, and separate interests in other real property, if any. 6. The condominium plan shall mean the condominium plan recorded or to be recorded pursuant to Section 1351 of the California Civil Code respecting the development and any amendments thereto. 7. The declarant shall mean Santa Barbara Savings and Loan Association, its successors and assigns, if such successors and assigns acquire or hold record title to all or any portion of the development for development purposes. 8. A member shall mean every person or entity who holds a membership in the association. 9. A mortgage shall mean a mortgage or deed of trust encumbering a condominium or other portion of the development. A mortgage shall also mean an installment sales contract as to a condominium or other portion of the development entered into under and pursuant to Article 3, Chapter 6, Division 4 of the California Military and Veterans Code, whereunder the Department of Veterans Affairs of the State of California, DVA, is seller a CalVet contract. The term mortgagee shall include the beneficiary under a deed of trust and the DVA under a CalVet contract. 10. An owner shall mean each person and entity holding a record ownership interest in a condominium, including declarants. The term owner shall not include persons or entities who hold an interest in a condominium merely as security for the performance of an obligation or as a contract purchaser, provided, however, that the contract purchaser or purchasers of a condominium from the DVA under a CalVet contract shall be an owner. 11. The development means the entire parcel or real property above described, divided or to be divided into condominiums, including all structures and improvements thereon. The development is a statutory condominium project as defined in Section 1353 of the California Civil Code. 12. A unit shall mean the elements of a condominium which are not owned in common with the other owners of condominiums in the development. The boundaries of a unit are shown and described on the condominium plan. In interpreting deeds and plans, the existing physical boundaries of a unit or of a unit reconstructed in substantial accordance with the original plans thereof shall be conclusively presumed to be its boundaries, rather than the description expressed in the deed or plans, regardless of minor variance between boundaries shown on the plans or in the deed and those of the building. Whenever reference is made herein, in the condominium plan, in any deed or elsewhere, to a unit, it shall be assumed that such reference is made to the unit as a whole, including each of its component elements, and to any and all exclusive easements appurtenant thereto over common area, if any.
Article 2.
Property rights, rights of enjoyment, and easement. 1. Ownership of condominium. Exclusive easements. Ownership of each condominium within the development shall include a unit, the respective interest in the common area, as specified in Exhibit B, which undivided interest may not be altered or changed, so long as the prohibition against severability of component interests in a condominium remains in effect as hereinafter provided, and any exclusive easement or easements appurtenant to such unit over the common area as described in the deed thereto or in the condominium plan, if any. 2. Owners' non-exclusive easements of enjoyment, etc. Every owner of a condominium shall have a non-exclusive easement of use and enjoyment in and to and throughout the common area of the development, as well as a non-exclusive easement for ingress, egress, and support over and through the common area, provided, however, such non-exclusive easements shall be appurtenant to and pass with the title to every unit. Title to every unit, and easements appurtenant thereto shall be subject to the following restrictions. A. The right of the association to limit the number of guests and to adopt association rules and regulations regulating the use and enjoyment of the common area. B. The right of the association to charge reasonable admission and other fees for the use of any unassigned parking and storage spaces and any recreational facilities situated upon the common area. C. The right of the association to borrow money for the purpose of improving the common area. D. The right of the association to assign, rent, license, or otherwise designate and control use of unassigned parking and storage spaces within the common area, other than those portions subject to appurtenant to units, if any. E. The right of declarant or its designees to enter upon the development for purposes of construction of the development and for purposes of making repairs and remedying construction defects. F. The right of the association or its agents to enter the common area and any of the units in order to perform its obligations hereunder, which right shall be immediate in case of an emergency originating in or threatening such unit, whether the owner is present or not. G. The right of any owner or his representatives to enter the unit of any other owner of the common area for purposes of performing permissible installations, alteration, or repairs to plumbing and utilities, and to mechanical or electrical services, including installation of television antenna and related cables, provided requests for entry are made in advance, and that such entry is at a time convenient to the owner whose unit is being entered. And in the case of emergency, such right of entry shall be immediate. 3. Delegation of use. Any owner may delegate his rights of enjoyment in the development, including any recreational facilities thereof, to the members of his family, his guests, and invitees, and to such other persons as may be permitted by the bylaws and said association, rules and regulations, provided, however, that neither an owner of a condominium who has sold same to a contract purchaser thereof or has leased or rented same, nor members of his family, his guests, and invitees shall be entitled to use and enjoy the recreational facilities of the development, while such owner's condominium is occupied by such contract purchaser, lessee, or renter. But, instead, such contract purchaser, lessee, or renter, while occupying such condominium shall be entitled to use and enjoy the recreational facilities of the development, and to delegate the rights of enjoyment in the same manner as if such contract purchaser, lessee, or renter were the owner of such condominium during the period of his occupancy of such condominium. Each owner shall notify the Secretary of the Association of the names of all persons to whom such owner, contract purchaser, lessee, or renter has delegated any rights of enjoyment in the development, and the relationship which each such person bears to such owner, contract purchaser, lessee, or renter. Any rights of enjoyment delegated pursuant hereto are subject to suspension to the same extent that rights of owners are subject thereto. 4. Minor encroachments. If any portion of the common area encroaches upon any of the units, or any portion of any unit encroaches upon the common area, a valid easement for such encroachment, and for the maintenance of same so long as same shall remain, shall and does exist, and pursuant to this declaration, all units are made subject to such easements. In the event that any structure containing a unit is partially or totally destroyed, and then rebuilt so as to encroach upon the common area, a valid easement for such minor encroachments, and for the maintenance of same so long as same shall remain, shall and does exist. And pursuant to this declaration, all units in the common area are made subject to such easements for minor encroachment. 5. Easements granted by association. The association shall have the power to grant and convey to any third-party easements and rights of way in, on, over, or under the common area for the purpose of constructing, erecting, operating, or maintaining thereon, therein, or thereunder, overhead or underground lines, cables, wires, conduits, or other devices for electricity, cable television, power, telephone, and other purposes, public sewers, stormwater drains and pipes, water systems, sprinkling systems, water heating and gas lines or pipes, and any similar public or quasi-public improvements or facilities. And each purchaser, in accepting a deed to his condominium, expressly consents hereto, provided, however, that no such easements may be granted if same would interfere with the use, occupancy, or enjoyment by an owner of his unit, any exclusive easements over common area appurtenant thereto, if any, or the recreational facilities of the development.
Article 3.
Use restrictions. 1. Residential use. Units shall be used for residential or parking or storage purposes only, provided, however, that for a period of 2 years from and after the date of recordation of this declaration, units owned by declarant may be used by declarant or its designees as models, sales offices, and construction offices for the purpose of developing, improving, and selling condominiums in the development and for the purpose of developing, improving, and selling any real property or portions thereof owned by declarant or its designees and situated in the vicinity of the development. Nothing herein shall prevent an owner from leasing or renting his condominium, provided, however, any lessee or renter thereof shall abide by and be subject to all terms and provisions of this declaration, the articles and bylaws, and the association rules. 2. Commercial use. Excepting as otherwise expressly provided in this declaration, no part of the development shall ever be used or caused, allowed or authorized to be used in any way, directly or indirectly, for any business, commercial, manufacturing, mercantile, storing, vending, or other such non-residential purpose, provided, however, that the right of declarant or its designees to the non-exclusive use of the common area and the facilities thereon for display and exhibit purposes in connection with the sale of said condominiums, which right declarant hereby reserves. Provided, however, that such use shall not be for a period of more than 2 years after conveyance of the first condominium, provided further, that no such use by declarant or their designees shall unreasonably restrict the members of their use and enjoyment of the common area. 3. Interior maintenance. Each owner of a condominium shall be responsible for maintaining his unit, including the equipment and fixtures therein, and the interior walls, ceilings, windows, and doors thereof, in a clean, sanitary, workable, and attractive condition, reserving to each owner, however, complete discretion as to the choice of furniture, furnishings, and interior decorating, provided, however, any windows may only be covered by drapes or shades and may not be painted or covered by foil, cardboard, or other similar materials. Each owner shall also be responsible for repair, replacement, and cleaning of the windows and glass of his unit, both exterior and interior. Unless otherwise specifically provided in this declaration, the association shall clean and maintain exclusive easements appurtenant to any of the units over the common area, if any. 4. Offensive conduct, nuisances. No noxious or offensive activities shall be carried on, upon, or within the development, nor shall anything be done thereon which may be or become an annoyance or nuisance to the residents of the development, or which shall in any way interfere with the quiet enjoyment of occupants of condominiums. Unless otherwise permitted by the board, no owner shall serve food or beverages, cook, barbecue, or engage in similar activities, excepting within such owner's unit, and excepting within those portions of the common area subject to exclusive easements appurtenant to such owner's unit, if any, and excepting those parties specifically so designated by the board. 5. Parking restrictions. Use of garages. Unless otherwise permitted by the board, no automobile, motorized vehicle, including motorcycles, or bicycle, shall be parked or left on any property subject to this declaration, other than on or within a garage, carport, or assigned or appurtenant parking stall or space. Provided, however, parking by commercial vehicles for the purpose of making deliveries shall be permitted in accordance with the association rules. Garages and carports, if any, shall be used for storage and/or the parking of automobiles, motorized vehicles, and bicycles only, and shall not be converted for living or recreational activities. Garage doors, if any, shall remain closed at all times, excepting when entering or exiting, and excepting when cleaning or otherwise maintaining the garage. 6. Signs. No sign or any kind shall be displayed to the public view on or from any condominium or on or from the common area without the approval of the board, excepting such signs as may be used by the declarant or its designees for the purpose of developing, selling, renting, and improving condominiums within the development, and for the purpose of developing, selling, renting, and improving real property owned by declarants or their designees and situated in the vicinity of the development. Notwithstanding the foregoing, one sign of reasonable dimensions advertising a condominium for sale or rent may be placed within each unit or within the common area immediately adjacent thereto by the owner or owners thereof, or his or their agent. 7. Antenna, external fixtures, etc. No television or radio antenna, poles, flagpoles, clotheslines, or other external fixtures other than those originally installed by declarant or approved by the board, if any, and any replacements thereof, shall be constructed, erected, or maintained on or within the common area, including any structures thereof. Each owner shall have the right to maintain television or radio receiving antenna, but not transmitting antenna, within completely enclosed portions of his unit. The foregoing notwithstanding, nothing herein shall be construed as restricting declarant or its designees from utilizing flags, poles, placards, markers, and the like in connection with sales and rental activities, provided same are removed upon termination of such activities. 8. Fences, etc. No fences, awnings, ornamental screens, screen doors, sunshades, walls, or other exterior improvements of any nature shall be erected or maintained on or around any portion of any structure, or elsewhere within the development, except such as are installed in accordance with the original construction of the development, and any replacement thereof, or as are authorized and approved by the board. 9. Animals. Only one domesticated dog or cat, not to exceed 25 pounds, caged birds not to exceed 2, and fish in a household aquarium may be kept and maintained in a unit, provided the same are not kept, bred, or raised therein for commercial purposes. The association shall have the right to prohibit maintenance of any animal which constitutes, in the sole and exclusive opinion of the board, a nuisance to any other owner. No pet shall be permitted in the common area except as allowed by rules and regulations adopted by the board. 10. Restricted use of recreation vehicles, etc. No boat, truck, trailer, camper, recreational vehicle, or temporary structure shall be used as a living area while permitted by the board to be parked or maintained within the development. Provided, however, that trailers or temporary structures for use incidental to the initial construction of the development or the initial sales of units therein, or incidental to the initial construction of any property owned by declarant or declarant's designees and situated in the vicinity of the development or the initial sales therein, may be maintained within the development, but shall be promptly removed upon completion of all such initial construction and all such initial sales. 11. Trash disposal. Trash, garbage, or other waste shall be kept only in sanitary containers. No owner of a condominium shall permit or cause any trash or refuse to be kept on any portion of the development subject to this declaration other than in the receptacles customarily used therefor. The location of trash containers placed outside of units shall be approved by the board. All rubbish, trash, and garbage shall be regularly removed from the properties at the expense of the association and shall not be allowed to accumulate thereon. 12. Outside drying and laundering. No exterior clotheslines shall be erected or maintained, and there shall be no exterior drying or laundering of clothes on balconies, patios, porches, or other areas, or from windows. 13. Structural alterations and integrity. Excepting as to alterations and modifications either made by declarant or its designees, or made with the prior approval in writing of the board, no structural alterations to the interior of any unit shall be made. No plumbing, electrical, or other work within any bearing or common walls, if any, shall be made. And no exterior alterations or modifications of any kind, including those to the exterior of the buildings, patios, balconies, fences, railings, or walls, shall be made. Nothing shall be kept or used in any condominium or elsewhere within the development which might impair the structural integrity thereof. Waterbeds may only be used with the prior written consent of the board. 14. Compliance with laws, etc. Nothing shall be done or kept in any unit or in any common area which might increase the rate of or cause the cancellation of insurance on the development or any portion thereof without the prior written consent of the board. No owner shall permit anything to be done or kept in his unit which is in violation of any law, ordinance, statute, rule, or regulation of any local, county, state, or federal body. No owner shall allow furniture, furnishings, or other personal belongings of such owner to remain within any portion of the common area, excepting portions thereof subject to exclusive easements over common area appurtenant to such owner's unit, if any, and excepting as may otherwise be permitted by the board. 15. Identification. Each owner shall be liable to the remaining owners for any damage to the common area which may be sustained by reason of the negligence of said owner, members of his family, his contract purchasers, lessees, renters, guests, or invitees, to the extent that any such damage shall not be covered by insurance. Each owner does, further, by acceptance of his deed, agree for himself and for the members of his family, his contract purchasers, lessees, renters, guests, or invitees, to indemnify each and every other owner, and to hold him or her harmless from and to defend him or her against any uninsured claim of any person or persons for personal injury or property damage occurring within the unit of the indemnifying owner, and any exclusive easements over the common area appurtenant thereto, if any, unless said injury or damage occurred by reason of the negligence of any other owner or person temporarily visiting in said unit or portion of the common area, subject to an exclusive easement appurtenant thereto, if any. 16. Owner's obligation for taxes. Each owner shall be obligated to pay any taxes or assessments assessed by the county or any subdivision, district, or agency thereof against his condominium and against his personal property. 17. Number of residents per unit. Not more than 2 adults and 1 child may be permitted to reside in 1-bedroom unit, and not more than 4 persons in a 2-bedroom unit, and not more than 6 persons in a 3-bedroom unit. 18. Rights. No unit shall be used in such manner as to interfere with the enjoyment of occupants of other units or annoy them by unreasonable noises or otherwise, nor shall any nuisance or immoral or illegal activity be committed or permitted to occur in any unit. No owner shall repair any vehicle or equipment in his garage, parking space, or in the common area, except pursuant to rules and regulations adopted by the board. 19. Children. Each owner shall be accountable to the remaining owners, their families, visitors, guests, and invitees for the conduct and behavior of their children and any visiting children temporarily residing in or visiting his unit. 20. Leasing. With the exception of a lender in possession of a condominium unit following a default of a first mortgagee, a foreclosure proceeding, or any deed or other arrangement in lieu of a foreclosure, no unit owner shall be permitted to lease his unit for transient or hotel purposes. Any lease agreement shall be required to provide that the terms of the lease shall be subject in all respect to the provisions of the declaration and the bylaws of the association, and that any failure by the lessee to comply with the terms of such documents shall be a default under the lease. All leases shall be required to be in writing.
Article 4.
The Association. 1. Formation. The association shall be organized as an association under the laws and decisions of the state of California, and upon the close of the first condominium sale to an owner shall be and become charged with the duties and invested with the powers set forth in the bylaws and this declaration, including, but not limited to, control and maintenance of the common area and any facilities thereof, if any. 2. Association Action Board of Governors and Officers. Except as to matters expressly requiring the approval of members as set forth in this declaration and the bylaws, the affairs of the association shall in all instances be conducted by the board and such officers as the board may elect or appoint. Such election or appointment to be in accordance with the bylaws, as the same may be amended from time to time. Except as otherwise expressly provided in this declaration or the bylaws, all matters requiring the approval of members shall be deemed approved if members holding not less than a majority of the total voting rights, present in person or by proxy at a duly constituted meeting, at which a quorum is present, assent thereto by vote, or if written consent thereof is obtained, as provided in the bylaws. Provided, however, that if the approval of any matter is sought at any time when there are two classes of membership still in effect, then, and in that event, such matter shall only be deemed approved if, in lieu of the foregoing, members holding not less than a majority of the Class A voting rights and members holding not less than a majority of the Class B voting rights assent thereto by vote, or if written consent thereof is obtained as provided in the bylaws. 3. Powers and duties of association. A. Powers. The association shall have all the powers of an association under the laws and decisions of the state of California, subject only to such limitations upon the exercise of such powers as are expressly set forth in the bylaws and this declaration. It shall have the power to do any and all lawful things which may be authorized, required, or permitted to be done by the association under this declaration and the bylaws, and to do and perform any and all acts which may be necessary or proper for, or incidental to, the exercise of any of the express powers of the association, including without limitation the following. 1. Assessments. The association shall have the power to establish, fix, and levy assessments against the owners of condominiums and to enforce payment of such assessments, all in accordance with the provisions of this declaration. Provided, however, the approval of members shall be required as to the amounts of all regular assessments except as otherwise hereinafter specifically provided. 2. Right of enforcement. The association and any owner shall have the power and authority from time to time in its or his own name and on its or his own behalf or on behalf of any owner or owners who consent thereto to commence and maintain actions and suits at law for damages or inequity, to restrain and enjoin any breach or threatened breach of any provisions of this declaration or the bylaws or of the association rules adopted pursuant to Section 3 of this Article 4 or any resolutions of the board, and to enforce by mandatory injunction or otherwise all of said provisions. In addition to the foregoing remedies, the association shall have the right to suspend the voting rights, suspend use privileges of the common area, or assess monetary penalties against any owner or other person entitled to exercise such rights or privileges by reason of any violation of this declaration or the bylaws, association rules, or board resolutions, provided, however, that A. Any such suspension of use privileges may not exceed a period of 30 days for any one violation, and B. Any such monetary penalty shall not exceed $25 for any one violation. Each fined or suspended owner or other person shall have the right to appeal such action by filing with the board written notice of his intention to appeal. Such action imposing such fine or suspension shall thereupon become ineffective until the fine or suspension shall thereafter be approved by a majority of board members present at a duly called and held regular or special meeting of the board at which a quorum is present, and the owner or other person to be fined or suspended shall have the right to appear, to be represented by counsel, and to be heard thereat. 3. Delegation of powers. The association acting by and through the board shall have the authority to delegate its powers, duties, and responsibilities to committees or employees, including a professional managing agent, sometimes hereinafter referred to as the manager. Any manager, except a resident manager, shall be a real estate broker duly licensed under the laws of the state of California. 4. Association rules. The association shall have the power to adopt, amend, and repeal such rules and regulations as it deems reasonable, hereinafter sometimes referred to as the association rules. The association rules shall govern the use of the common area, including, but not limited to, any recreational facility, and private streets by an owner, the family members of an owner, or by any guest, invitee, contract purchaser, lessee, or renter of an owner, or their respective family members, guests, or invitees, provided, however, that the association rules shall not be inconsistent with or materially alter any other provisions of this declaration or bylaws. A copy of the association rules is the same may, from time to time, be adopted, amended, or repealed, shall be mailed or otherwise delivered to each owner, and a copy shall be posted in a conspicuous place within the development. In the event of any conflict between any such association rules and any other provisions of this declaration or bylaws, the provisions of the association rules shall be deemed to be superseded by the provisions of this declaration or bylaws to the extent of any such inconsistency. B. Duties of the association. In addition to powers delegated to it by this declaration or in the bylaws, and without limiting the generality thereof, the association acting by and through the board, or by and through persons or entities described in paragraph A3 above, if applicable, shall have the obligation to conduct all business affairs of common interest to all owners, and to perform each of the following duties. 1. Operation and maintenance of common area. Operate, maintain, and therewise manage or provide for the operation, maintenance, and management of the common area, and all facilities, improvements, and landscaping thereon and thereof, including all private driveways and private streets thereof, if any, and all other property acquired by the association, including personal property, in a first-class condition and in a good state of repair. In this connection, the association may employ a managing agent, may enter into contracts or arrangements for service or materials for the benefit of or improvement of the association or the common area, or may sell property owned by it, provided, however, that 1. The term of any such service contract shall not exceed 1 year. 2. The aggregate expenditures for capital improvements to the common area in any fiscal year shall not exceed 5% of the budgeted gross expenses of the association for that fiscal year. And 3. The association shall not sell during any fiscal year property owned by it having a value greater than 5% of the budgeted gross expenses of the association for the fiscal year, unless such action is approved by vote or written consent of a group of members holding a majority of the total voting rights, which group of members shall, in any event, include a subgroup of members, excluding declarant, holding not less than a majority of the total voting rights, excluding any such voting rights held by declarant. Provided, however, that if the association seeks to approve such action at any time when there are two classes of members still in effect, then, and in that event, such matters shall instead require approval by vote or written consent of members holding not less than majority of the Class A voting rights. Notwithstanding the foregoing, the above described limitation on the term of any contract shall not apply to 1. A contract with a public utility company if the rate charged for the materials or services is regulated by the Public Utilities Commission, so long as the term thereof does not exceed the shortest term for which the supplier will contract at the regulated rate. And 2. A prepaid casualty and/or liability policy of not to exceed 3 years' duration, provided such policy permits, short rate cancellation by be insured. 2. Taxes and assessments. Pay all real and personal property taxes and assessments, and all other taxes levied against the common area personal property owned by the association or against the association. Such taxes and assessments may be contested or compromised by the association, provided, however, that they are paid or a bond ensuring payment is posted prior to the sale or the disposition of any property to satisfy the payment of such taxes. 3. Insurance. Obtain from reputable insurance companies and maintain in effect the insurance described in Article 8 hereof. 4. Enforcement of restrictions and rules. Perform such other acts, whether or not expressly authorized by this declaration, as may be reasonably necessary to enforce any of the provisions of this declaration and bylaws and the association rules and board resolutions. 4. Personal liability. No member of the board or any committee of the association or any officer of the association or the manager, if any, or declarant or any agent of declarant shall be personally liable to any owner or to any other party, including the association, for any damage, loss, or prejudice suffered or claimed on the account of any act, omission, error, or negligence of any such person or entity, provided that such person or entity has, upon the basis of such information as may be possessed by him or it, acted in good faith without willful or intentional misconduct. 5. Annual meeting and notice. An organizational meeting shall be held as soon as practicable following the commencement of the association, and the Board of Governors elected thereat shall hold office until the first annual meeting. The first annual meeting of members of the association shall be held within 45 days after the closing of the sales of 51 of the condominiums within the development, but in no event shall such first annual meeting of members be held later than 6 months after the closing of the sale of the first condominium within the development. Thereafter, annual meetings of members of the association shall be held in each succeeding year, within 1 week before or after the anniversary date of said first annual meeting, on a day to be determined by the board, which day shall not be a legal holiday. Special meetings may be called as provided for in the bylaws. Notice of all members' meetings, annual or special, shall be given by regular mail or telegram, and shall be given not less than 10 days, nor more than 30 days, prior to the time of said meeting, and shall set forth the place, date, and hour of the meeting, and the nature of the business to be undertaken. All such meetings shall be held within the development or as close thereto as possible, at a reasonable place selected by the board, which place shall, in any event, be located within said county. The presence at any meeting, in person or by proxy, of members entitled to cast at least 50% of the total votes of all members of the association shall constitute a quorum. If any meeting cannot be held because a quorum is not present, no business may be transacted, but members representing a majority of the votes present, either in person or by proxy, may adjourn the meeting to a time not less than 5 days, nor more than 30 days, from the time the original meeting was called, at which adjourned meeting the quorum requirement shall be at least 25 of said total votes. Any meeting of members whereat a quorum is present may be adjourned for any reason to a time not less than 5 days nor more than 30 days from the time of such meeting by members representing a majority of the votes present thereat in person or by proxy. 6. Annual meeting and notice. An organizational meeting shall be held as soon as practicable following the commencement of the association, and the Board of Governors elected thereat shall hold office until the first annual meeting. The first annual meeting of members of the association shall be held within 45 days after, but in no event shall such first annual meeting of members be held later than 6 months after the closing of the sale of the first condominium within the development. Thereafter, annual meetings of members of the association shall be held in each succeeding year, within 1 week before or after the anniversary date of said first annual meeting, on a day to be determined by the board, which day shall not be a legal holiday. Special meetings may be called as provided for in the bylaws. Notice of all members' meetings, annual or special, shall be given by regular mail or telegram, and shall be given not less than 10 days nor more than 30 days prior to the time of said meeting, and shall set forth the place, date, and hour of the meeting, and the nature of the business to be undertaken. All such meetings shall be held within the development or as close thereto as possible, at a reasonable place selected by the board, which place shall, in any event, be located within said county. The presence at any meeting in person or by proxy of members entitled to cast at least 50% of the total votes of all members of the association shall constitute a quorum. If any meeting cannot be held because a quorum is not present, no business may be transacted, but members representing a majority of the votes present, either in person or by proxy, may adjourn the meeting to a time not less than 5 days, nor more than 30 days from the time the original meeting was called, at which adjourned meeting the quorum requirement shall be at least 25% of said total votes. Any meeting of members whereat a quorum is present may be adjourned for any reason to a time not less than 5 days, nor more than 30 days from the time of such meeting by members representing a majority of the votes present thereat in person or by proxy. 7. Balance sheet and operating statement. The association shall prepare or cause to be prepared a balance sheet and an operating income statement for the association as of the accounting dates hereinafter set forth, and copies of each thereof shall be distributed to each member within 60 days after said accounting dates. For purposes hereof, the accounting dates for the preparation of such balance sheet and operating income statement are as follows. A. First accounting date. The first accounting date shall be the last day of the month closest in time to 6 months from the date of closing of the first sale of a condominium within the development. The balance sheet shall be rendered for the period commencing with the date of closing of the first sale of a condominium within the development and ending as of said first accounting date. B. Subsequent annual accounting dates. The second and subsequent accounting dates shall be the last day of the association's fiscal year, which fiscal year shall be a calendar year unless a different fiscal year is adopted. The balance sheet shall be rendered as of said date, and the operating income statement shall be rendered for the fiscal year of question. C. First operating income statement. The operating income statement for the first 6 months accounting period shall include a schedule of assessments received or receivable, itemized by unit number and by the name of the person or entity assessed. An external audit by an independent public accountant or certified public accountant shall be required for the preparation of the balance sheets and operating income statements referred to in B above for fiscal years in which the gross income of the association exceeds $75,000.
Article 5.
Membership and voting rights. 1. Membership. A. Qualifications. Each owner of a condominium, including declarant, shall be a member of the association. No such owner shall hold more than one membership in the association, even though such owner may own or own an interest in more than one condominium. Ownership of a condominium or interest therein shall be the equalization for and entitlement to membership in the association. Each owner shall remain a member of the association until such time as his ownership or ownership interest in all condominiums in the development ceases for any reason, at which time his membership in the association shall automatically cease. A member is not intended to include persons or entities who hold an interest in a condominium merely as security for performance of an obligation, nor is a member intended to include contract purchasers, excepting, however, a contract purchaser or contract purchasers from the DVA under a Calvet contract, if any. B. Members' rights and duties. Each member shall have the rights, duties, and obligations set forth in this declaration, the bylaws, and the association rules, as the same may from time to time be amended. C. The association membership of each person or entity who owns or owns an interest in one or more condominiums shall be appurtenant to each such condominium and shall not be assigned, transferred, pledged, hypothecated, conveyed, or alienated in any way except upon a transfer of title to each such condominium or interest therein, and then only to the transferee thereof. Any attempt to make a prohibited transfer shall be void. Any transfer of title to a condominium or interest therein shall operate automatically to transfer the membership rights in the association appurtenant thereto to the new owner thereof. 2. Voting. A. Number of votes. The association shall have 2 classes of voting memberships. Class A. Class A members shall be all the owners with the exception of declarant. Each Class A member shall be entitled to 1 vote for each condominium in which such Class A member owns an interest. Provided, however, when more than 1 Class A member owns an interest in a condominium, the vote for such condominium shall be exercised as they among themselves determine. But in no event shall more than 1 vote be cast with respect to any one such condominium, except in the case of cumulative voting, as hereafter described. Class B. The Class B member shall be the declarant, who shall be entitled to 3 votes for each condominium owned, except in the case of cumulative voting as hereafter described. The Class B membership shall cease and be converted to Class A membership on the happening of either of the following events, whichever occurs earlier. 1. When the total votes outstanding in the Class A membership equal the total votes outstanding in the Class B membership. 2. On the 2nd anniversary of the original issuance by the California Department of Real Estate of the final subdivision report for the development. B. Joint owner votes. The voting rights for each condominium may not be cast on a fractional basis. In the event that the joint owners of a condominium are unable to agree among themselves as to how their voting rights shall be cast, they shall forfeit name as to the matter in question. If any owner or owners cast the voting rights of a particular condominium, it will thereafter be conclusively presumed for all purposes that he or they were acting with the authority and consent of all other owners of the same condominium. In the event more than 1 person or entity casts the voting rights for a particular condominium, said voting rights shall not be counted and shall be deemed void. C. Cumulative voting. Excepting as otherwise provided herein, election to and removal from the board shall be by cumulative voting. In this regard, each member shall be entitled to vote in person or by proxy as many votes as such member is entitled to exercise as above provided multiplied by the number of governors to be elected or removed as the case may be, and he may cast all of such votes for and against a single candidate or governor, or he may distribute them among the number of candidates or governors to be so elected or removed, or any 2 or more of them in such manner as he deems appropriate. The candidates receiving the highest number of votes up to the number of governors to be elected shall be deemed elected. As to removal, the entire board or any single governor may be removed from office by a vote of members, utilizing cumulative voting procedures as aforesaid, holding a majority of the total voting rights permitted to vote in respect to such action. Provided, however, unless the entire board is removed, an individual governor may not be removed prior to the expiration of his term of office if the number of votes cast against his removal is greater than the quotient arrived at when the total number of votes that may be cast under such cumulative voting procedures is divided by 1 plus the authorized number of governors. From the first election of the governing body and thereafter, for so long as a majority of the voting power of the association resides in the subdivider, or so long as there are 2 outstanding classes of membership in the association, not less than 20% of the incumbents on the governing body shall have been elected solely by the votes of owners other than the subdivider. A governing body member who has been elected to office solely by the votes of members of the association other than the subdivider may be removed from office prior to the expiration of his term of office only by the vote of at least a simple majority of the voting power residing in members other than the subdivider.
Article 6.
Assessment. 1. Agreement to pay. The declarant, for each condominium owned by it in the development which is expressly made subject to assessment as set forth in this declaration, hereby covenants and agrees, and each purchaser of a condominium by his acceptance of a deed therefor, whether or not it is so expressed in such deed, is deemed to covenant and agree, for each condominium owned, to pay to the association regular assessments and special assessments, such assessments to be established, made, and collected as hereinafter provided. 2. Personal obligation. Each such assessment or installment thereof, together with any late charge, interest thereon, collection cost, and reasonable attorney's fees, shall also be the personal obligation of the person or entity who was an owner at the time such assessment or installment thereof became due and payable. In the event more than one person or entity was the owner of a condominium, the personal obligation to pay such assessment or installment thereof respecting such condominium shall be both joint and several. The personal obligation for delinquent assessments or delinquent installments thereof, and such other sums shall not pass to an owner's successors in interest unless expressly assumed by them. No owner of a condominium may except himself from payment of assessments or installments thereof by waiver of the use of enjoyment of all or any portion of the common area, or by waiver of the use or enjoyment of, or by abandonment of, his condominium. 3. Purpose of assessments. The assessments levied by the association shall be used exclusively to promote the recreation, health, safety, and welfare of the members of the association, the improvement, operation, and maintenance of the common area, and the performance of the duties of the association as set forth in this declaration. 4. Assessments. A. Regular assessments. Not less than 60 days prior to the beginning of each fiscal year, the board shall cause a pro forma operating statement, budget, for such fiscal year to be prepared and distributed to members. Such budget shall contain an estimate per condominium of the total amount of funds necessary to defray the common expenses of the association for such fiscal year. And if said amount is approved by the members, the same shall become the basis for regular assessments for such fiscal year. If said amount is not approved by members, the prior fiscal year's budget shall apply to such fiscal year subject to increases set forth in Section 8 hereof. Said assessments shall be determined as provided in Section 5 hereof. B. Special assessments. In the event the board shall determine that the theretofore estimated total amount of funds necessary to defray the common expenses of the association for a given fiscal year is or will become inadequate to meet such expenses for any reason, including but not limited to unanticipated delinquencies, costs of construction or reconstruction, unexpected repairs or replacement of capital improvements upon the common area, or otherwise, the board shall determine the approximate amount necessary to defray such expenses. And if said amount is formally approved by the board, shall become a special assessment which may be assessed hereunder. The board may in its discretion prorate such special assessment over the remaining months of the fiscal year, or levy such assessment immediately against each condominium. C. Limitation respecting special assessments. The foregoing notwithstanding, excepting as otherwise herein provided, any such special assessment in excess of 5% of the budgeted gross expenses of the association for the fiscal year in which such special assessment is to be levied shall require approval by vote or the written consent of a group of members holding a majority of the total voting rights, which group of members shall in any event include a subgroup of members, excluding declarant, holding not less than a majority of the total voting rights, excluding declarant's voting rights. Provided, however, that if the association seeks to levy a special assessment in excess of the aforesaid limitation at any time when there are 2 classes of members still in effect, then, and in that event, Such special assessment shall require approval by vote or written consent of members holding not less than a majority of the Class B voting rights. 5. Rate of assessment. Except as otherwise specifically provided elsewhere in this declaration, regular and special assessments for each condominium must be fixed in proportion to the respective interest of each such condominium in the common area as specified in Exhibit B hereto. 6. Assessment period. The regular assessment period shall coincide with the association's fiscal year, and regular assessments shall be payable in equal monthly installments unless the board adopts some other basis for collection. Provided, however, the initial regular assessment period shall commence on the first day of the month following the date on which the sale of the first condominium to a purchaser is closed, hereinafter referred to as the initiation date, and shall terminate on the last day of the fiscal year in which the initial sale is consummated. The first regular assessment and all special assessments shall be adjusted according to the number of months remaining in the fiscal year, and shall be payable in equal monthly installments, unless the board adopts some other basis for collection. The association shall not change the pro rata interest or obligation of any condominium for purposes of levying assessments, unless all owners and all mortgagees have given their prior written consent thereto. On the initiation date, regular assessments shall commence as to all condominiums within the development, including unsold condominiums owned by declarant. 7. Notice and assessment installment due date. A single 10-day prior written notice of each yearly regular assessment and each special assessment shall be sent to the owner or owners of every condominium subject thereto, wherein the due dates for the payments of installments thereof shall be specified. The due dates for the payment of installments of regular assessments and special assessments shall normally be the first day of each month, unless some other due date is established by the board. Each installment of regular assessments and special assessments shall become delinquent, if not paid within 15 days after its due date. There shall accrue with each delinquent installment a late charge of $15, together with interest at the rate of 10% per annum, calculated from the due date and including the date full payment is received by the association. 8. Increase in assessments. Notwithstanding the foregoing, the board may, for the fiscal year following the initial fiscal year and any subsequent fiscal year, increase the regular assessments effective as of the first day of such fiscal year by an amount not in excess of 20% above the maximum annual assessment per condominium for the previous fiscal year, without the vote or consent of a majority of the members of the association, other than the subdivided. 9. Estoppel certificate. The board or manager, upon not less than 20 days prior written request, shall execute, acknowledge, and deliver to the party making such request a statement in writing stating whether or not to the knowledge of the association a particular owner is in default as to said owner's condominium under the provisions of this declaration, and further stating the dates to which installments of assessments, regular or special, have been paid as to such condominium, it being intended that any such certificate delivered pursuant to this section 9 may be relied upon by any prospective purchaser or mortgagee of said condominium. But reliance on such certificate may not extend to any default not involving the payment of assessments as to which the signer had no actual knowledge.
Article 7.
Collection of assessments. Liens. 1. Right to enforce. The right to collect and enforce assessments is hereby vested in the board acting by and on behalf of the association. The board or its authorized representative, including the manager, if any, may enforce the obligations of the owners to pay assessments provided for in this declaration by commencement and maintenance of a suit at law or in equity, or the board may foreclose by judicial proceedings or through the exercise of the power of sale pursuant to Section 3 hereof to enforce the lien rights created hereby. Suit to recover a money judgment for unpaid assessments or installments thereof, together with all other amounts described in Section 2 of Article 6 hereof, shall be maintainable without foreclosing or waiving said lien rights. 2. Creation of lien. In the event of a delinquency in the payment of any assessment or installment thereof, respecting a condominium, as described in Section 7 of Article 6 hereof, such amount as may be delinquent, together with the late charge described in said Section 7, interest thereon at the rate of 10% per annum, and all costs which may be incurred by the board or its authorized representative in the collection of said amount, including reasonable attorney's fees, shall be and become a lien against such condominium upon the recordation in the office of the county recorder of said county of a notice of assessment as provided in Section 1356 of the California Civil Code. The notice of assessment shall not be recorded unless and until the board or its authorized representative has delivered to the delinquent owner or owners of such condominium, not less than 15 days prior to the recordation of said notice of assessment, a written notice of default and a demand for payment, and such delinquency has not been cured within 15 days after delivery thereof. Said lien shall expire and be null and void unless, not less than 10 days, nor more than 1 year after recordation of said notice of assessment, the board or its authorized representative records a notice of default as hereinafter provided or institutes judicial foreclosure proceedings. 3. Notice of default, foreclosure. Not less than 10 days, nor more than 1 year after the recording of said notice of assessment, the board or its authorized representative may record a notice of default, and thereafter may cause such condominium to be sold in the same manner as a sale is conducted, as provided by sections 2924 et seq. Of the California Civil Code, or through judicial foreclosure, provided, however, that in connection with any sale pursuant thereto, the board is hereby authorized to appoint its attorney, any officer or governor, or any title insurance company authorized to do business in California, as trustee for purposes of conducting such sale. If any such delinquency is cured prior to sale or prior to completing a judicial foreclosure, the board or its authorized representative shall cause to be recorded in the office of the county recorder of said county a certificate setting forth the satisfaction of such claim and release of such lien upon payment of actual expenses incurred, including reasonable attorney's fees not to exceed $150 by such delinquent owner or owners. During the pendency of any foreclosure proceedings, whether judicial or by power of sale, the condominium owner or owners shall be required to pay to the association reasonable rental for the condominium, and the association shall be entitled to the appointment of a receiver to collect the same. In this regard, on becoming delinquent in the payment of any assessments or installments thereof, each delinquent owner or owners shall be deemed to have absolutely assigned all rents, issues, and profits of his condominium to the association, and shall further be deemed to have consented to the appointment of a receiver, which appointment may, at the election of the association, be enforced by the association by the remedy of specific performance. The association, acting on behalf of the owners, shall have the power to bid on the condominium at foreclosure sale and to acquire, hold, lease, mortgage, and convey the same. 4. Waiver of exemptions. Each owner does hereby waive, to the extent of any lien created pursuant to this Article 7, the benefit of any homestead or exemption laws of the state of California in effect the time any assessment or installment thereof becomes delinquent or any lien is imposed pursuant to the terms hereof.
Article 8.
Insurance. 1. Liability insurance. The association shall obtain and maintain in force comprehensive public liability insurance ensuring the association, the manager, if any, the declarant, and the owners and occupants of condominiums, and their respective family members, guests, and invitees, and the agents and employees of each, against any liability incident to the ownership or use of the common area and including, if obtainable, a cross-liability endorsement ensuring each insured against liability to each other insured. The minimum amount of such insurance shall not be less than $500,000 for death or injury to any one person in any one occurrence, $1 million for death or injury to more than one person in any one occurrence, including property damage in any one occurrence. 2. Fire and extended coverage insurance. The association shall also obtain and maintain in force a master or blanket policy of fire insurance for 100% of the insurable value of all of the improvements within the development. Such policy and any endorsements thereon shall be in the form and content for such term and in such company as may be satisfactory to any mortgagee. And if more than one mortgagee has a loan of record against the development or any part thereof, such policy and endorsements shall meet the minimum standards of the various mortgagees represented in the development. Such policy shall contain extended coverage and replacement cost endorsements, if available, and may also contain vandalism and malicious mischief coverage, special form endorsement, stipulated amount clause, and a determinable cash adjustment clause, or a similar clause to permit cash settlement covering full value of the improvements in the event of partial destruction and a decision not to rebuild. Such policy shall be in such amounts as shall be determined from time to time by the board, shall name as insured the association, the owners and declarant, so long as declarant is the owner of any of the condominium, and all mortgages as their respective interests may appear, and may contain a loss payable endorsement in favor of the trustee hereinafter described. 3. Individual fire insurance. If available, Underlying fire insurance coverage for individual condominiums shall be written as a part of or in conjunction with said master policy, where necessary to protect individual lenders. If such coverage is not available, each owner or owners of each condominium shall purchase at his or their expense and maintain such fire and casualty coverage as may be required by his or their individual mortgagee. Any such underlying insurance shall contain a replacement cost endorsement, if available, and, to the extent available, such other endorsements as may be a part of the master policy. Such insurance shall likewise name as insured all of the owners and declarant, so long as declarant is the owner of any of the condominium, and all mortgages, as their respective interests may appear, and may contain a loss payable endorsement in favor of the trustee hereinafter described.
4. Trustee. All insurance proceeds payable under Sections 2 and 3 above and subject to the rights of the mortgagees may be paid to a trustee to be held and expended for the benefit of the owners, mortgagees, and others as their respective interests shall appear. Said trustee shall be the association or commercial bank or branch thereof in said county, which is agreed in writing to accept such trust. In the event repair or reconstruction is authorized, the board shall have duty to contract for such work as provided for herein. 5. Other insurance. The board may purchase and maintain enforced demolition insurance in adequate amounts to cover demolition in the event of total or partial destruction and a decision not to rebuild. The board shall also purchase and maintain workers' compensation insurance to the extent that the same may be required by law for all employees of the development, and governors and officers' errors and omissions insurance. The board may also purchase and maintain fidelity bonds, insurance on personal property owned by the association, and such other insurance that it deems necessary. 6. Owner's insurance. An owner may carry such personal liability and property damage insurance respecting his condominium as he may desire, provided, however, such policy shall include a waiver of subrogation clause.
Article 9.
Destruction of improvements. 1. Destruction. Proceeds exceed 85% of reconstruction costs. In the event of a total or partial destruction of the improvement in the development, and if the available proceeds of the insurance carried pursuant of Article 8 are sufficient to cover not less than 85% of the costs of repair and reconstruction thereof, the same shall be promptly rebuilt. 2. Destruction. Proceeds less than 85% of reconstruction costs. If the proceeds of such insurance are less than 85% of the costs of repair and reconstruction, such repair and reconstruction shall nevertheless take place unless, within 90 days from the date of said destruction, members, excluding declarant, then holding at least 75% of the total voting power of the association and their respective mortgagees determine that such repair and reconstruction shall not take place at a duly constituted meeting of members. If repair and reconstruction is not to take place, the board shall be required to execute, acknowledge, and record in the office of the county recorder of said county, not later than 120 days from the date of such meeting, a certificate declaring the intention of the members not to rebuild. 3. Procedures respecting rebuilding. If rebuilding is to take place, pursuant to Sections 1 or 2 above, the owner or owners of each condominium shall be obligated to contribute such funds as shall be necessary to pay his or their proportionate share of the cost of reconstruction, over and above the available insurance proceeds, and the proportionate share of each such owner or owners shall be the same as his or their respective interest in the common area. In the event of the failure or refusal of such owner or owners to pay his or their proportionate share, the board may, without the consent or approval of members, any provisions hereof to the contrary notwithstanding, levy a special assessment against the condominium of such owner or owners, which may be enforced under the lien provisions contained in Article 7 hereof, or in any other manner provided in this declaration. For purposes hereof, the proportionate share of an owner or owners of the cost of reconstruction shall be increased as to such owner or owners by the amount of insurance proceeds paid to the mortgagee of the condominium of such owner or owners, and in respect to such condominium. 4. Contract rebuilding. If rebuilding is to take place, the board or its authorized representative shall obtain bids from at least 2 reputable contractors and shall award the repair and reconstruction work to the lowest qualified bidder. The board shall have the authority to entertain a written contract with said contractor for such repair and reconstruction, and the available insurance proceeds shall be dispersed to said contractor according to the terms of the contract. It shall be the obligation of the board to take all steps necessary to assure the commencement and completion of such repair and reconstruction at the earliest possible date if same is to take place. 5. Rebuilding, not authorized. If the members determine not to rebuild, then, subject to the rights of mortgagees, any insurance proceeds then available for such rebuilding shall be distributed to the owner or owners of each condominium proportionally in accordance with the respective interest in the common area of each such condominium, as specified in Exhibit B hereto. 6. Minor repair and reconstruction. The foregoing notwithstanding, the board shall have the duty to repair and reconstruct improvements without the consent of members and irrespective of the amount of available insurance proceeds. In all instances of partial destruction, where the estimated cost of repair and reconstruction does not exceed 5% of the association's annual maintenance budget, the board is expressly empowered to levy a special assessment without the consent of members for the cost of same, to the extent insurance proceeds are unavailable therefore. Such assessments to be levied as described in Section 3 hereof. 7. Revival of right to partition. Upon recordation of a certificate described in Section 2 hereof, the right of any owner to partition through legal action, as described in Article 11 hereof, shall forthwith revive. 8. Arbitration. In the event of a dispute among the owners or mortgagees with respect to the provisions of this Article 9, any owner may cause the same to be referred to arbitration in accordance with the then prevailing rules of the American Arbitration Association. In the event of arbitration, notice thereof shall be given to the members of the board and to all other owners and their respective mortgagees as promptly thereafter as possible, giving all board members, owners, and mortgagees an opportunity to appear in such arbitration proceeding. The decision of such arbitrator in the matter shall be final and conclusive upon all parties. The arbitrator may include in his decision an award for costs and/or attorney's fees against any one or more parties to the arbitration. The award may be confirmed and enforced by any court of competent jurisdiction. 9. Negligently or willfully cause damage. Any owner or other person negligently or willfully causing damage to the development which is not covered by insurance shall be liable therefor.
Article 10.
Condemnation. 1. Sale by unanimous consent. In the event that an action for condemnation of all or a portion of the development is proposed or threatened by any governmental agency having the right of eminent domain, then, upon unanimous written consent of all of the owners, the development or such portion thereof may be sold. 2. Distribution of proceeds of sale. Upon a sale occurring as described in Section 1 hereof, the proceeds resulting therefrom shall be distributed to the owner or owners of each condominium proportionately in accordance with the respective interest in the common area of each such condominium as specified in Exhibit B hereto. In the event of the occurrence of a disagreement within 90 days after the proceeds of sale become available for distribution, the matter shall be referred to arbitration in accordance with Section 8 of Article 9. 3. Distribution of condensation award. In the event the development or such portion thereof is not sold, but is instead taken, the judgment of condemnation shall, by its terms, apportion the award among the owners and their respective mortgagees. 4. Revival of right to partition. Upon a sale or taking pursuant hereto, which renders more than 50% of the units in the development uninhabitable, the right of any owner or partition through legal action shall forthwith revive.
Article 11.
Partition. 1. Suspension. The right of partition is hereby suspended pursuant to Section 1354 of the California Civil Code as to the development which comprises a condominium project as defined in Section 1350/3 of the California Civil Code. The development may be partitioned and sold as a whole pursuant to the provisions of Section 1354 of the California Civil Code, upon a showing of the occurrence of any one of the events therein provided. Additionally, partition may be had of the development upon a showing that the conditions for such partition, as set forth in Section 7 of Article 9, have been met. Nothing herein contained shall prevent the partition or division of interest between joint or common owners of one condominium. 2. Power of attorney. Pursuant to Section 1355(b)(9) of the California Civil Code, each of the owners hereby grants the association an irrevocable power of attorney to sell the development for the benefit of the owners thereof, when partition thereof may be had under applicable California law. Exercise of such power shall be subject to approval of members.
Article 12.
Non-severability of component interest in a condominium. 1. Prohibition against severance. No owner shall be entitled to sever his unit in any condominium from his undivided interest in the common area specified in Exhibit B hereof for any purpose. Neither of said component interests may be severally sold, conveyed, encumbered, hypothesized, or otherwise dealt with, and any violation or attempted violation of this provision shall be void and of no effect. Similarly, no owner shall be entitled to sever any exclusive easement appertinent to his unit over the common area from his condominium, and any attempt to do so shall be void and of no effect. The suspension of this right of severability will in no event extend beyond the period set forth in Article 11 respecting the suspension of partition. It is intended hereby to restrict severability pursuant to Section 1355B of the California Civil Code. 2. Conveyances. Subsequent to the initial sales of the condominiums, any conveyance of a unit or of the component interest in the common area by the owner of any condominium shall be presumed to convey the entire condominium, provided, however, that nothing herein contained shall be construed as precluding the owner of any condominium from creating a co-tenancy or joint tenancy in the ownership of said condominium with any other person or person.
Article 13.
Term of declaration. Compliance with rule against perpetuities. Subject to the provisions of Section 1 of Article 15, this declaration shall run with the land and shall continue in full force and effect for a period of 59 years from and after the date on which this declaration is executed, after which time same shall be automatically extended for successive periods of 10 years, unless an instrument executed by not less than a majority of the owners of the condominiums and all mortgagees of condominiums shall be recorded, canceling and terminating this declaration.
Article 14.
Protection of mortgages. 1. Mortgage permitted. Any owner may encumber his condominium with a mortgage or mortgages. 2. First mortgagee, meaning herein a mortgagee under a mortgage encumbering a condominium with priority over other mortgages encumbering such condominium. Upon request will be entitled to written notification from the association of any default in the performance by the individual unit holder of any obligation under the condominium documents, meaning collectively the within instrument, the article's bylaws, association rules, and board resolutions, which is not cured within 60 days. 3. Right of first refusal. Any right of first refusal contained in the condominium documents shall not impair the rights of a first mortgagee to 1. Foreclose or take title to a condominium unit pursuant to the remedies provided in the mortgage, or 2. Interfere with a subsequent sale or lease of a unit so acquired by the mortgagee. 4. Unpaid dues. Any first mortgagee who obtains title to a condominium unit pursuant to the remedies provided in the mortgage or by foreclosure of the mortgage shall not be liable for such units' unpaid dues or charges which accrue prior to the acquisition of title to such by the mortgagee. 5. Amendment. No amendment to this declaration shall affect the rights of any mortgagee under any mortgage made in good faith and for value, and recorded prior the recordation of any such amendment, unless said mortgagee shall either join in the execution of such amendment or shall approve the same in writing as a part of such amendment. 6. Restriction on certain changes. Unless at least 75% of the first mortgagees, based upon one vote for each mortgage owned, of condominiums have given their prior written approval, neither the association nor any owner shall be entitled A. By act or omission to seek or abandon or terminate the condominium plan of the project. B. To change the pro rata interest or obligations of any condominium for 1. Purposes of levying assessment or charges or allocating distributions of hazard insurance proceeds or condemnation awards. 2. Determining the pro rata share of ownership that an owner has in the common area. C. To partition or subdivide any condominium or unit. D. By act or omission to seek to abandon, partition, subdivide, encumber, sell, or transfer the common area. The granting of easements for public utilities or for other public purposes consistent with the intended use of the common area by the association or the owners of declarant or this declaration shall not be deemed a transfer within the meaning of this clause. E. To use hazard insurance proceeds for losses for other than the repair, replacement, or reconstruction of development improvements, except as provided by applicable statute in case of substantial loss to the units or common area. Notwithstanding the foregoing, no change described in B1 or 2 above may be made without the consent of owners holding a majority of the total voting rights. 7. Right to examine books and records. First mortgagees shall have the right to examine the books and records of the association or the condominium project. 8. Reserve fund. Condominium dues or charges shall include an adequate reserve fund for maintenance, repairs, and replacement of these common elements that must be replaced on a periodic basis and shall be payable in regular installments rather than by special assessments. 9. Distribution of insurance and condemnation proceeds. No owner or any other party shall have priority over any right of first mortgagees of condominiums pursuant to their mortgages in the case of a distribution to owners of insurance proceeds or condemnation awards for losses to or a taking of units of common area. Any provisions to the contrary herein or in the bylaws or other documents relating to the project is to such extent void. All applicable fire and all physical loss or extended coverage insurance policies shall contain loss payable clauses, naming the mortgagees as their interests may appear. 10. Amenities. All amenities such as parking, recreation, and service areas which are available for use by owners, and with respect to which regular or special assessments for maintenance or other uses may be levied hereunder, constitute common area, and shall be covered by any mortgage on a unit. 11. Contracts. Agreements. Any agreement for professional management of the condominium project or any other contract providing for services of the developer, sponsor, or builder may not exceed 3 years. Any such agreement must provide for termination by either party without cause and without payment of a termination fee on 90 days or less written notice. 12. Notice of loss or taking. Upon any loss to or taking of A. the common area, if such loss or taking exceeds $10,000, or B. any condominium or unit, if such loss or taking exceeds $1,000, and said condominium or unit is covered by a mortgage purchased in whole or in part by the Federal Home Loan Mortgage Corporation. Notice in writing of such loss or taking shall be given to all mortgages named in first mortgages on condominiums or units, together with a copy of said notice addressed to the Federal Home Loan Mortgage Corporation, care of the applicable first mortgagee, in the event a first mortgage encumbering a condominium or unit has been purchased by the Federal Home Loan Mortgage Corporation. 13. Flood insurance. If at any time flood insurance is required by any mortgagee of a condominium or by any lender who desires to become a mortgagee of any condominium by reason of any applicable law, ordinance, statute, or the like requiring flood insurance as a condition of such mortgagee's or lender's loan remaining or being made, the association shall forthwith obtain such flood insurance, covering the entirety of the condominium project in amount and coverage, and with such carriers and subject to such terms as shall satisfy such mortgagee or lender. 14. Insurance required by FHLMC. If any loan secured by a mortgage encumbering a condominium is owned by FHLMC or its successors or assigns, or is tendered to FHLMC or its successors or assigns for purchase, the association and the owners shall obtain and maintain in full force and effect all insurance coverages which may at any time and from time to time be required by FHLMC or its successors or assigns, and shall otherwise comply in all respects with all insurance requirements of FHLMC which may be in effect at any time and from time to time. 15. Calvet contracts. As to Calvet contracts, the board is expressly authorized to adopt such resolutions as may be required in connection with Calvet financing, in order to reflect the fact that such Calvet contracts are superior in right to the assessment liens created in the within instrument, in the same manner and to the same extent as mortgages and deeds of trust are superior thereto. 16. Notice to first mortgagees. In the event that any owner is in default under any provision of this declaration or under any provision of the bylaws or the rules and regulations adopted by the association, which default is not cured within 60 days after written notice thereof to such owner, the association shall, if a written request for notice is on file with the association, give to the first mortgagee of such owner's condominium written notice of such default and of the fact that said 60-day period has expired. 17. Effective breach hereof. No breach of any provision of this declaration shall invalidate the lien of any mortgage made in good faith and for value, but all said covenants, conditions, and restrictions shall be binding upon any owner whose title is derived through foreclosure sale, trustee's sale, or otherwise. 18. Non-curable breach. Any mortgagee who acquires title to a condominium by foreclosure shall not be obligated to cure any breach of this declaration which is non-curable or of a type which is not practical or feasible to cure. 19. Loan to facilitate. Any mortgage given to secure a loan to facilitate the resale of a condominium after acquisition by foreclosure shall be deemed to be a loan made in good faith and for value and entitled to all of the rights and protections of this Article 14. 20. Appearance at meetings. Because of its financial interest in the project, any mortgagee may appear but may not vote at meetings of the association and the board of directors thereof to draw attention to violations of this declaration which have not been corrected or made the subject of remedial proceedings or assessment. 21. Right to furnish information. Any mortgagee shall have the right to furnish information to the board of directors concerning the status of any mortgage. 22. Inapplicability of right of first refusal to mortgagee. A right of first refusal or option to purchase, if any, granted in this declaration or any amendment hereof the association, or to any other person, firm, or entity, shall not apply to any convenience or transfer of title to any condominium, whether voluntary or involuntary, to a mortgagee which acquired title to or ownership of said condominium pursuant to the remedies provided in its mortgage, or by reason of foreclosure of the mortgage. 23. Definition of mortgage. For purposes hereof, the term mortgage shall mean and include deed of trust. The term mortgagee shall mean and include beneficiary under deed of trust. And the term first mortgage shall mean and include a beneficiary under a deed of trust with priority over all other mortgages and deeds of trust. 24. Liens. All taxes, assessments, and charges which may become liens prior to the first mortgage under local law shall relate only to the individual condominium units and not to the condominium project as a whole. 25. Conflicting provisions. In the event of any conflict between provisions of this declaration other than this Article 14 and the provisions of the Article 14, the provisions of this Article 14 shall prevail.
Article 15.
Amendment. 1. Amendment prior to close of first sale. Prior to the close of the first sale and the development to a purchaser other than declarant, this declaration and any amendments thereto may be amended in any respect or revoked by the execution by declarant of an instrument amending or revoking same, which instrument shall make appropriate reference to this declaration and any amendment thereto, and which instrument shall be acknowledged and recorded in the office of the county recorder of said county. 2. Amendment subsequent to close of first sale, except as otherwise expressly herein provided, subsequent to the close of the first sale and the development to a purchaser other than declarant, this declaration may be amended in any respect by any group of members holding not less than 75% of the total rights, which group of members shall in any event include a subgroup of members, excluding declarant, holding not less than 75% of the total voting rights, excluding any such voting rights held by declarant, by vote as hereinafter provided, or by their execution of an instrument amending same, which instrument shall make appropriate reference to this declaration and any amendments thereto, and which instrument shall be acknowledged and recorded in the office of the county recorder of said county, provided, however, that if approval of such amendment is sought at any time when two classes of members are still in effect, then, and in that event, this declaration shall instead be amended in any respect only by members holding not less than 75% of the Class A voting rights and members holding not less than 75% of the Class B voting rights by vote as hereinafter provided, or by their execution of an instrument amending same, which instrument shall make appropriate reference to this declaration and any amendments thereto, and which instrument shall be acknowledged and recorded in the office of the county recorder of said county. The foregoing notwithstanding, the percentage of votes or voting rights necessary to amend any specific provision or clause of this declaration shall not, in any event, be less than the prescribed percentage of affirmative votes or voting rights required for action to be taken under that specific provision or clause. Whenever in this Article 15 members holding a specified percentage or percentages of votes or voting rights are required to execute an instrument to be recorded in order to effectuate an amendment, then, in lieu thereof, a special meeting of members may be held, and if members holding a specified percentage or percentages of votes or voting rights assent by vote to such amendment at such meeting, then, and in that event, the secretary or any other officer of the association may sign such instrument to be recorded and certify therein that such assent by vote to such amendment was duly obtained as aforesaid from members holding such specified percentage or percentages of votes or voting rights. Any such instrument bearing such officer's certificate shall have the same effect as though executed by owners of such specified percentage for percentages of votes or voting rights. 3. Business and Professions, Code Section 11018.7. The foregoing to the contrary, notwithstanding, all amendments, revocations of this declaration shall comply with the provisions of Section 11010.7 of the California Business and Professions Code to the extent said section is applicable thereto. 4. Reliance on amendments. Any amendments made in accordance with the terms of this declaration shall be presumed valid as to anyone relying thereon in good faith.
Article 16.
General provisions. 1. Headings. The headings used in this declaration are for convenience only and are not to be used in interpreting the meaning of any of the provisions of this declaration or otherwise. 2. Severability. The provisions of this declaration shall be deemed independent and severable, and the invalidity or partial invalidity or unenforceability of any provision or provisions hereof shall not invalidate any other provisions hereof. 3. Cumulative remedies. Each remedy provided for in this declaration shall be cumulative and not exclusive. Failure to exercise any remedy provided for in this declaration shall not, under any circumstances, be construed as a waiver thereof. 4. Violations as nuisance. Every act or omission in violation of the provisions of this declaration shall constitute a nuisance and, in addition to all other remedies herein set forth, may be abated or enjoined by any owner, any member of the board, the manager, or the association. 5. No racial restriction. No owner shall execute or cause to be recorded any instrument which imposes a restriction upon the sale, leasing, or occupancy of his condominium on the basis of race, color, or creed. 6. Districts. To the extent permitted by law, no owner shall oppose the formation of any district in which the development would be included. 7. Access to books. Any owner may, at any reasonable time, and upon reasonable notice to the board or manager, and at his own expense, cause an inspection to be made of the books and financial records of the association as provided in the bylaws. 8. Liberal construction. The provisions of this declaration shall be liberally construed to effectuate its purpose of creating a plan of condominium ownership for the development. Failure to enforce any provisions hereof shall not constitute a waiver of the right to enforce said provision thereafter. 9. Notification of sale of condominium. Concurrently with the consummation of the sale of any condominium under circumstances whereby the transferee becomes an owner thereof, or within 5 business days thereafter, the transferee shall notify the board in writing of such sale. Such notification shall set forth the name of the transferee and his transferor, the street address of the condominium purchased by the transferee's mailing address, and the date of sale. Prior to receipt of such notification, any and all communications required or permitted to be given by the association, the board, or the manager shall be deemed to be duly made and given to the transferee, if duly and timely made and given to said transferee's transferor. Mailing addresses may be changed at any time upon written notification to the board. Notices shall be deemed received 48 months after mailing, if mailed to the transferor or to his transferor, if the board has received no notice of transfer, as above provided, by certified mail, return receipt requested, at the mailing address above specified. Notices shall also be deemed received 1. 24 hours after being sent by telegram, or 2. Upon personal delivery to any occupant of a condominium over the age of 12 years. 10. Number. Gender. The singular shall include the plural, and the plural the singular unless the context requires the contrary, and the masculine, feminine, and neuter shall each include the masculine, feminine, or neuter, as the context requires. 11. Exhibits. Any and all exhibits attached hereto shall be deemed made a part hereof and incorporated by reference herein. 12. A. Easements reserved and granted. Any and all easements referred to herein shall be deemed reserved or granted, or both reserved and granted, as appropriate, by reference to this declaration in a deed to any condominium. 13. Binding effect. This declaration shall inure to the benefit of and be binding upon the successors and assigns of the declarant, and the heirs, personal representatives, grantees, lessees, successors, and assigns of the owners. 14. Unsegregated real estate taxes. Until such time as real estate taxes have been segregated by the county assessor of said county, same shall be paid by the respective owners of condominium. In connection with such payment, the proportionate share of such taxes for particular condominium shall be determined by dividing the initial sales price or offered initial sales price of such condominium by the total initial sales prices and offered initial sales prices of all condominiums within the development. The term offered initial sales prices of all, the price at which an unsold condominium is then being offered for sale by declarant. If, and to the extent, same are not paid by any owner or owners of a condominium and are allowed to become delinquent, same shall be collected from the delinquent owner or owners by the association. 15. Attorney's fees. Should suit be instituted hereon, hereunder, or in connection herewith, to enforce any of the terms or provisions hereof, or to obtain any of the remedies provided for herein, the prevailing party shall be entitled to an award of reasonable attorney's fees from any court of competent jurisdiction. 16. Limitation on rights of tenants. No tenant or lessee of a unit shall be a governor or officer of the association. 17. Indemnification of officers and governors. Every governor, And every officer of the association shall be and is hereby indemnified by the association against all expenses and liabilities, including fees of counsel, reasonably incurred by or imposed upon such officer or governor in connection with any proceeding to which he may be a party, or in which he may become involved by reason of his being or having been an officer or governor of the association, or any settlement thereof, whether or not he is a governor or officer at the time such expenses are incurred, except in such cases wherein the governor or officer is adjudged guilty of willful misfeasance or malfeasance in the performance of his duties, provided that in the event of a settlement, the indemnification herein shall apply only when the board approves such settlement and reimbursement as being in the best interests of the association. The foregoing right of indemnification shall be in addition to, and shall not be exclusive of, all rights to which each such governor or each such officer may otherwise be entitled. 18. Waiver, unenforceability. Each owner, by acceptance of a deed to his condominium, shall be deemed to have agreed that declarant shall have no liability whatsoever resulting from any term or provision hereof having been held to be unenforceable, in whole or in part. 19. Use of funds collected by the association. All funds collected by the association, including assessments, both regular and special, and contributions to the association paid by owners on close of their unit purchases, if any, shall be held in trust by the association, to be expended in their entirety for not-for-profit purpose of the association in maintaining, preserving, and architecturally controlling the development, and for other permitted purposes as set forth in this declaration. The payment of any regular or special assessment or installment thereof, or contribution, present or future, by any owner, is expressly conditioned upon the obligation of the association to treat such amount, when received, in a fiduciary manner solely for such purposes. For any breach of this fiduciary obligation, any amount so paid by an owner shall forthwith be returned to him. 20. Additional provisions. Additional provisions are set forth in Exhibit C, attached hereto. 21. Specially elected governor. Notwithstanding any other provision hereof to the contrary, so long as all owners other than declarant do not possess a sufficient number of votes by the application of cumulative voting to elect at least one governor, the election of one governor, a specially elected governor, shall be determined at a special election held immediately prior to the holding of the regular election of governors, except in the case of the election of a specially elected governor following removal of his predecessor as noted below. In this regard, at the duly constituted meeting of members in question, nominations for the specially elected governor shall be made from the floor. When nominations have been closed, the special election shall take place. Declarant shall not have the right to participate in or vote in such special election, although a representative of declarant may be present thereat, and the candidate receiving the highest number of votes shall be deemed to be the specially elected governor, and his term shall be the same as that of any other governor. Unless members, excluding declarant, holding a majority of all voting rights, excluding any voting rights held by declarant, assent thereto by vote or written consent, such specially elected governor may not be removed. In the event of the death, resignation, or removal of a specially elected governor, his successor shall be elected at a special meeting of members, and the provisions above set forth respecting the election of a successor thereof. Except as otherwise expressly provided herein, the provisions of this declaration and of the articles and bylaws applicable to governors shall apply to a specially elected governor. 22. Rental or leasing of condominiums. Any owner leasing or renting his condominium shall nevertheless a. Be liable to the association for all obligations contained in this declaration, including the obligations to pay assessments in respect to his condominium. B. Be liable to and responsible to the association for any violations of this declaration committed by his renter or lessee, or any persons entering his condominium with the permission of or at the request of his renter or lessee. C. Be deemed to have agreed in connection with such renting or leasing that upon being requested so to do by the association he will immediately take such action or actions in respect to his renter or lessee as may be necessary or required to cause such renter or lessee to fully comply with each and all of the terms and provisions of this declaration, bylaws, articles, association rules if any, and resolutions of the board, and upon failing to take such action or actions, the association may then take such action or actions, including the institution of proceedings in unlawful detainer, if required, against such renter or lessee, and the costs of all such action or actions taken by the association, including fees of counsel, shall be charged to such owner, and the association may obtain reimbursement therefore by any remedies set forth in this declaration or at law. And D. Be deemed to have agreed to save, hold harmless, indemnify, and defend the association of and from any and all claims, demands, actions, causes of action, liabilities, damages, and expense arising out of or incurred as a result of the leasing or renting by such owner of his condominium, together with all costs, expenses, and fees of counsel resulting therefrom. Prior to renting or leasing his condominium, an owner shall obtain and deliver to the board from his proposed renter or proposed lessee a written statement to the effect that such renter or lessee agrees to be bound by and abide by each and all of the terms and provisions of this declaration, the articles, bylaws, association rules, if any, and resolutions of the board, which written statement may, if such owner desires, be contained in the rental agreement or lease. 23. Storm drains. The Homeowners Association is responsible for the maintenance for the storm drain located on the southerly boundary of the tract. As said, storm drain is not a publicly owned culvert. The Homeowners Association is responsible for that portion located on the common area, including the inlet and pipe. In witness whereof, declarant has executed this instrument as of this 10th day of January, 1980.
Plan of development.
1. Declarant proposes to improve the real property described in Exhibit A hereof by constructing thereon improvements containing a total of 25 residential condominium units, consisting of 7 2-bedrooms, 11 baths, 2-story townhomes, and 18 3-bedrooms, 25 baths, 2-story townhomes, 25 double-enclosed garages, all in accordance with plans and specifications on file with the City of Rosemead, California. 2. The common area consists of Lot 1 of Tract Number 35592, excepting therefrom the 25 residential condominium units and the 25 double-enclosed garages of the development, which said units are specifically defined in the condominium plan. 3. The respective interests in the common area to be conveyed with each unit are specified in Exhibit B attached hereto and made a part hereof.
Look at that! We made it! This concludes the Covenants, Conditions, and Restrictions of Rushwood. Your time matters, and I'm glad you gave some of it to this. You just might be the change Rushwood needs. It's clear these CC&Rs were written for a different time. The years ahead will test us, financially, emotionally, and yes, as neighbors. And we'll face this again and again. Growth isn't always pretty. It takes honesty, patience, and the courage to face what no longer serves us. What has always been true is this: change doesn't require perfection, just the willingness to show up, speak up, and try, even when it's uncomfortable. And remember, success isn't found in the outcome, only in the valor of the attempt. We're in this together, whether we like it, admit it, or pretend we didn't hear it. But hey, at least now we know what we agreed to.
Sort of.